Today's sponsor spotlight guest is Paul Terry, co-founder and managing partner of Angius and Terry, construction defects attorneys. Paul, thank you so much for joining us this morning and being part of our sponsor spotlight interview series. Before we begin, please tell us about yourself, your law firm, and how your company works within the association industry.
Well, thank you, Jill. We've been in the industry for 35 years now. We specialize in the construction defect 558 claims, and we also handle developer transition. But like I said, we've been involved for many, many years. We're big sponsors of CAI, and so thank you for that.
Thank you.
And we're happy to help wherever we can.
Okay, well, let's start. We'll begin with transition. At what point do you enter into transition, and what practical advice do you have for the new board coming in?
Well, in today's economy, the transition process primarily is triggered by 90% of the sales being completed, and then that starts a statutory timeline, the first 90 days of which are what I call essentially a dead period. Nothing happens, it's just a delay. And I think that provides a real opportunity for both managers and for board members. For managers, it's an opportunity to convince the homeowners that are prospective board members that you have their interest at heart and not just the developers, and so that when the transition itself takes place, the first communication you don't get is a notice of termination. For the board members, it's an opportunity to perform an evaluation as to whether or not you want to keep your manager. And it's also an opportunity to get yourself organized so that you have pretty much already decided by the time the election process begins who's running, who's going to be holding which offices, so that you approach it in an organized manner.
Very good. Okay, so now let's transition into what is a construction defect? And how does an association board prove that a construction defect does exist?
Well, a construction defect is essentially any component or product that doesn't work the way you expect it to. There are some technical definitions that lawyers and experts have to be aware of, but for the average consumer, really the issue is something not working the way you'd expect it to be working, or are you performing maintenance or replacement sometime prior to the expected useful life of that component wearing
out. Okay, and what is a Chapter 558 and how does that work?
Okay, well, Chapter 558 has two primary components to it. The first, and the one that people are probably less aware of, is that it sets out a pre-litigation procedure that you must go through before you can file a lawsuit. That procedure involves presenting the builder with a notice of claim that spells out a reasonable description of the defects that you allege and where you allege they're located. It allows the developer to conduct an inspection, and then they have a total of 75 days to make some kind of proposal for a resolution of those defects. Then the homeowners association or the condominium association then can either accept that proposal, can negotiate, or can decide that the builder is not responding and proceed with litigation. The second half of it lays out some of the technical things, like the technical definition of a construction defect, which primarily is work falling below the standard of care, building code violations, other things like that, and then rules for who you can name in the lawsuit and things like that. So it's got the technical side for when you file your lawsuit, and it's got the pre-litigation side for what you have to do before you can file a lawsuit.
Okay. And under a contingent fee agreement for a construction defect claim, who advances the costs?
Well, I can tell you who should advance the cost. The cost should be advanced by the attorney. There's a couple of reasons for that. One is that the attorney is really in the best place to decide and evaluate what kind of a case it is. And so the real advantage of a contingency is that the lawyer has to make a decision about how strong your case is. And the way they really express that is by spending their own money to pursue recovery and then expecting to get that money back out of the recovery. So all of the costs, really from day one, should be paid for by the law firm or by the attorney on a contingency fee.
And the final question for today is, what kinds of damages can be recovered in a construction defect case?
Well, the primary damages that are recovered are the cost of the repairs, which are both repairing actual damaged material, as well as putting the component back into the condition it should have been in had it been constructed correctly in the beginning. So basically the cost of repairs. In addition to that, you can recover the cost of amounts that you paid to repair defects before the lawsuit began, before you really even realized they were defects. So some of the more common examples of that are, you can recover for roof repairs, for interior damage, for different things like that that the association had to repair prior to the lawsuit proceeding.
Well, Paul, you have imparted valuable information today about your firm, developer transition, and construction defects. But before we conclude our time together, I'd like you to share one or two interesting facts about you.
Well, I guess probably the most interesting fact is that I'm a private pilot, and the firm owns their own airplane, and so we use that to fly around the state so that we can take care of our clients wherever they are, even if we don't have an office immediately next to it. I think the other interesting fact is that I am a volunteer cook in a soup kitchen, which I have done for many years. In fact, I'm even on the board of directors now, and we try to feed up to 200 people a day.
Wow, that's really, really cool. Very special. And I'd like to thank you for your time today, and also thank you for your support of CAI. I know you are a big proponent of CAI throughout the state, and with all your, and where are your offices again?
Yeah, so we have offices in Fort Lauderdale, in Orlando, and in Palm Harbor, which is a suburb of Tampa.
But again, as you mentioned, with your plane, you can go anywhere, reach anybody.
That is correct.
Okay, great. And if anyone needs Paul's information for to reach him, of course you can go through me, but it's Angus and Terry, and very easy to locate on the internet. So thank you again, Paul, for all of your very valuable information that you've given us today.
Thank you, Jill. I appreciate the opportunity.
Thank you.
Bye-bye.
Bye.